any morning. And we'll, as we go, we'll take questions as we go along. So please feel free to either raise your hand as a function, as a reaction in Zoom, or you can also put it in the chat. We'll be monitoring the chat as well for questions, and we will intermittently take pauses to try to answer some of those questions intermittently if we can. We have most of our advocates, I believe, will be on hand to answer questions, but if for some reason they aren't, Jay will do his best, but we will make sure that you can get connected with one of our advocates if you have a particular question about their area of expertise. Again, thank you so much for joining us this morning. And I will, our Executive Director, Jay Spear, will help get us started.
Okay, well, thanks everybody for joining. I'm going to cover a lot of different areas. You know, what I'm going to talk about is the things that we are affirmatively going to work on that we knew about beforehand, before the General Assembly started, but I'll tell you there's going to be a whole lot of things that will come up that we didn't know about. Because we work on, not only do we work on our legislation that we're trying to get passed, but we also work on analyzing legislation that other folks put in, and then we sometimes have to explain to legislators that, you know, how we think it ought to be changed, or maybe that we should oppose it. So you know, as we have a wide range of expertise on this call. I was looking at some of the folks coming in, but some people know all about the session, and I'm sure some folks don't have that much experience, but I'll tell you that last year, 3,064 bills were introduced in the House and Senate. And this year so far, it's over 400 in the House and 212 as last time I checked in the Senate. And this is the week where they really, a lot of bills come in. So we spend a lot of time trying to figure out what all these bills do and how it may affect low-income Virginians. As most of you all know, the Poverty Law Center, our mission is to use advocacy, education, and litigation to break down systemic barriers that keep low-income Virginians in the cycle of poverty. And so this is our advocacy role, not our litigation or education role that we're going to be talking about. And of course, we spend a lot of our energies in January and February at the Virginia General Assembly. It's interesting, the average person spends a lot more time thinking about what's happening on the federal level. But people, in my opinion, ought to be more focused on what's happening at the state and local level, because that really has more effect on the average person. Dana, can you go ahead and change the slide? So that we have different centers here at the Poverty Law Center. The first center we're going to talk about is a Center for Economic Justice, which covers affordable energy, consumer rights, and housing. So the first issue is affordable energy, and we have, over the last several years, have really delved into this issue and become, I think, an important voice at the General Assembly on these issues. But as the slide says, we're interested in driving down utility costs for consumers, because the cost of utilities is a big problem for low-income Virginians. And there's always a lot of bills on this, a lot of press coverage around this stuff. If you go to our website, we have this paper, or it's either, I'm not sure if it's a blog or a paper, called "Working to Rebuild Virginia's Energy Landscape into a Balanced and Equitable System." And that's sort of the crux of why we work on these issues. And whether it be regulatory tools, the balance, but you have to look at the balance between the need for consistent energy access and the need to protect consumer finances. Okay, Dana. This next issue is a brand new issue for us. This sort of was somewhat prompted by a 4-part series that aired on Virginia Public Media Radio and also in print last fall. The reporter looked into a hidden type of debt affecting thousands of Virginia college students. It's not federal student loans. which of course dominates the headline. It's money owed directly to institutions called direct-to-school debt. And I've talked to several people with this debt, and what happens is sometimes it's somebody in their third year, sometimes it's somebody in their second semester, but for whatever reason, typically they have to drop out. Sometimes it's a medical issue. I know one person told me about, she had a problem with a domestic abuser she had to get away from. But what happens is that they end up dropping out, and then either their loan doesn't cover that semester, or there's all sorts of reasons why, but they end up with owing a big tuition bill, and it becomes a real problem for these folks. And if it's the series on VPM is called Dreams Deferred, and I would recommend that to you. The reporter did a great job with that, and so we convinced a couple legislators along with our partner. We're not really the leads on this. Virginia 21 is the lead on this, but what we're trying to do is just stop the public universities and colleges from withholding people's transcripts when they owe a bill. And the reason for this is, you really have, you stop somebody from moving on. They can't get their transcript and complete their education somewhere else. Sometimes they can't get a job if they can't get their college transcripts. I talked to one lady here in Richmond who, after years of this, owing this debt, she decided to go back and complete her degree at a community college, but she's now going to have to retake about 5 or 6 courses because she can't get her transcript showing that she's already paid it. So that's the crux of that legislation. Okay, Dana. Improve control over consumer data. Last year, I think it was last year, there was a big bill passed about consumers controlling their own data. This is becoming just absolutely huge business in this country, is the buying and selling of consumer data. And a lot of people feel like consumers, us included, should have some control over how that data, your own data, is used and sold. And the legislation that passed was really inadequate. I mean, it attempted to address this issue, but the problem is it didn't set up a very good system for consumers being able to access their data. So we really have to this really has to be more fine-tuned. Dana? This has to do with establishing a fair system for collection of unpaid medical bills. Again, we're working with several partners on this, including the Legal Aid Justice Center. But this unpaid medical bills, of course, is just a huge problem for our clients and low-income Virginians in general, and particularly from the big public college hospitals. And what this legislation will attempt to do is create a system where you have to offer payment plans, you have to offer charitable care when it's available, to help people, to try to help people get these bills paid rather than to get sued and then have their wages garnished. Okay. I think you skipped one. Limitations on towing and storage fees. These bills, we heard from several legislators recently that they're going to put in legislation on this. This again is another big problem for our clients. Getting these, you have your car towed after an accident, and then they charge you $40 a day to store it, and before you know it, you owe hundreds of dollars. And so there's an attempt to bring more transparency to this process, and also try to put some limitations on these fees. So the next big area is housing, and so the Poverty Law Center has passed a lot, and along with many other people, has advocated for and gotten passed many bills improving things for tenants, but more needs to be done. And this first bill has to do with access to appeals in eviction cases. It allows the court to waive high fees so that low-income tenants can have access to an appeal. Otherwise, you really get no appeal unless you can put up a lot of money. It's just like all other civil cases. You can, if a person is low income, they can appeal without paying lots of fees, but it's only in eviction cases where that's not allowed, and we're trying to get rid of that exception. It doesn't make any sense. And we also want to eliminate the process of dismissal of appeals without a hearing. And the next thing has to do with Safe and Healthy Homes Act. Here in Richmond today, for the second time, the conditions at an apartment complex in South Richmond were on the front page of the Richmond Times-Dispatch because it surrounds this issue of how do tenants get landlords to make improvements or to fix things. And when you're low income or you're vulnerable in some other way, such as if you're an immigrant, then unfortunately some landlords will take advantage of that and not make the repairs. And one way of doing that, of addressing this problem, is to enact what's called a warranty of habitability defense. So if you get sued for your rent and you can raise the unsafe or unhealthy conditions as a defense to non-payment. I've seen in cases where people had to pay for repairs themselves and then they didn't have money for the rent. And I know a lot of states do this, so it's not an unusual thing to do this. Yes, go ahead. And then this, again, surrounding the very same issue, we do have a process in effect in Virginia. Again, due to these changes we have made the last couple of years, that you can pay your rent into escrow if you have bad conditions in order to force your landlord to fix things, or you can hire somebody to do the repairs and then make the landlord pay you back. But these are not the easiest tools for the average tenant to use. So the idea behind this legislation is to allow localities to help people make sure that slumlords force compliance with the health and safety standards. And I think, Dana, are there some questions on that?
Yes, we have some questions from Anne. How would warranty of habitability differ from the current process of tenant's assertion? And I think we have Christy Mara here who might be able to answer that question.
Go ahead, Christy.
Sure, that's a great question. So the tenant's assertion, as you know, Anne, it really is two things. It's a positive step. So it's something that a tenant can initiate and isn't necessarily used as a defense. However, as you point out, there is another code section that does allow a tenant to raise these poor habitability conditions as a defense if they've paid their rent into escrow. This would be a true defense in a non-payment of rent case, where as long as the tenant has given notice to the landlord of the unhealthy condition. I'm sorry, are we on the warranty of, you asked about the warranty of habitability defense, right, Anne?
Yeah, we already covered that, so go ahead. Yeah, go ahead.
That's the, I'm sorry, because we have the other thing on the screen.
Yeah, and then,
so this
sorry,
is,
go ahead, Christy.
This is an actual defense, and the idea is the judge can hear the evidence of the poor conditions and determine whether the tenant got the benefit of her bargain, or if in fact, because of the poor conditions, the value was less and therefore she's entitled to a reduction in her rent, which could result in a lower judgment, no judgment at all for the landlord, or the ability of the tenant to redeem with a lesser amount of rent.
And then I think we had another question, which I think you started to answer in the chat, Christy, which was for appeals of non-payment of rent cases, waiving bond, would that also address the existing requirements of paying monthly rent into the court on appeal?
No, we're not going. The bill doesn't change that. It changes two things. It allows the court to waive that appeal bond. The tenant would still have to pay ongoing rent, not necessarily into court, but would still have to pay ongoing rent to the landlord if the judge doesn't order that it be escrowed. The piece that it does change is that under current law, if a tenant does not make one of those monthly rent payments while the appeal is pending, the court can dismiss that case without a hearing. The law says that a landlord can file a notice to the court and a motion to dismiss, and the judge shall dismiss the case. No hearing, no due process. So that's the piece that this bill would change. It would essentially make appeals of non-payment of rent evictions the same as every other civil appeal for indigent defendants.
Thanks, Christy.
Any other questions on the housing issues?
I just moved to the next one, Jay.
Okay. So this is currently the law right now in Virginia, that you have to give, if you don't pay your rent, the landlord has to give you 14 days to pay or quit before a notice, and then before they can file an eviction. But it's only in effect until July 1st. And so what this legislation would do is make that permanent. Christy, do you want to say anything about that?
Just that we know it's going to be a fight. And so anyone who wants to get involved in helping us advocate for this to be permanent, please reach out to me or Laura.
I mean, the whole thinking here is that if somebody is unable to pay their rent, giving them 5 days doesn't do much good. But if you give somebody 14 days, there's a good chance they've been paid or they have some other income, and maybe they'll be able to pay it. And it's really kind of a win-win. Having less evictions is a win-win for landlords and tenants.
Right. And the other thing I will say is that there are other eviction protections that are definitely expiring June 30th. We know that what we call the budget language protection expires on July 1st. That's the language that requires landlords to tell tenants about the availability of rental assistance and help them apply for it, and doesn't allow them to file for an eviction until there's a decent amount of time for that money to come in. That goes away July 1st. Why do we want that and the 14-day pay or quit to go away on the same day? That seems like we're just inviting evictions and increased homelessness.
Okay, thanks, Christy. Any other questions on the housing before I move on? Okay. So domestic and sexual, under our Center for Family Advocacy, we cover domestic and sexual violence and family and child welfare. And basically, this is sort of more like we do a lot of analyzing what other folks put in on these issues and working with a lot of different coalitions. But the bottom line is we want to ensure victims don't fall through the gaps between various protective systems, and to support the work of partnering advocates in the field. I think, Sheila, could you explain that a little better? I'm not quite sure what that means.
Hi, everybody. I'm Sheila. I'm the domestic and sexual violence attorney. Let me put my video on. And basically what that means is we tend to work a lot with other advocates, other organizations' advocates. And sometimes there are issues that really affect the legal aid attorneys who are representing low-income domestic and sexual violence victims that we would take the lead on and either work or try to oppose. And sometimes there are more general victim services issues or funding for local programs that, for example, my colleague, Jonathan Iglesias, policy director of the Virginia Sexual and Domestic Violence Action Alliance, might take the lead on. So we work in conjunction, just like everybody else is at VPLC. But I wanted to, Jay, if you don't mind, I'll put it in the chat, these two bills. Basically, as the bills start to drop, we knew there would be a lot of bills that we would have to fight and kill. One of them is by Delegate Davis, and it's a bill he has brought many years in a row, and it's failed many years in a row. We have a broad coalition with the family law section of the bar, etc., to fight this. And it really is diminishing the best interests of the child factors that judges must consider for custody and visitation, and sort of raising up one parent's assertion for frequent contact with the child over all of those other factors that the judge is supposed to weigh. So we'll be opposing that. That's HB 69. And we just heard yesterday about a bill from Senator Peake, SB 174, which would, in a protective order, after a hearing, when the full protective order is issued by the judge, it's on behalf of the victim, the petitioner, against the abuser, the respondent. What Senator Peake wants to do is to allow that order to have all of these restrictions on the petitioner in the very order that's supposed to protect that petitioner. So that's unconstitutional because it doesn't allow for due process rights for this petitioner. There was no, notice of a hearing, opportunity to be heard, any sort of ability to defend against alleged allegations by the respondent. So that bill I'm hoping to kill as unconstitutional. And then I'll mute myself and let Jay continue.
Okay. Any other questions on domestic violence? Okay. So I'll move on to family and child welfare. Over the last few years, we've spent a lot of time.
Sorry, I think we did have one.
Go ahead.
Actually, I think this is under the public benefits section, so I'll hold that question for a moment.
Okay. Yeah, so as I say, we spent a lot of resources and energy working on foster care issues. And we think we've made a lot of improvements, again, with lots and lots of partners. But this year, we're looking at legislation to increase court oversight over foster care placements to ensure decisions made are in the best interests of the child. And then you can go to the next one. And then this one has to do with giving relatives of children in foster care an opportunity to appeal the denial of foster placement. Valerie, do you want to say something about that?
Sure, just really briefly, a lot of relatives want to become the foster parents of relative children when those children are removed from their parents, and they apply and then are denied the right to. And sometimes there's good reason for that, but a lot of times it's really that it's easier for the department to work with the foster families that they already know and they don't really want to work with the relative. So this just gives a relative the opportunity to appeal when there's not a really good reason for the denial.
All right, next slide, Dana. And I guess, Valerie, could I get you to explain this one too?
Sure. There have been a lot of studies over the past few years that show that when parents of children who are in foster care have really good attorneys with wraparound legal services, that things are actually improved for the children in foster care, because for one thing, they're more likely to go home or more likely to be reunited with another family member. But even if they end up being adopted, as many children in foster care are, it's more likely to happen sooner than later. And so children don't spend years in foster care wondering what's going to happen to them, which is really very bad for them. It really affects their life outcomes. So Virginia has terrible legal representation for children, that the attorneys are not trained and they're not paid very well. So this is a budget amendment just to create some pilot parent representation centers that would be modeled on those legal representation centers in other states that have been shown to be so successful, and to improve outcomes for children, and also to save money, because when children spend less time in foster care, the state spends less money on foster care. So we're hoping overall that this will actually save the state money, while also giving parents the due process that they deserve under the Constitution, as well as helping children to reunite with their birth family, or to at least exit foster care in a satisfactory way without just languishing for years in foster care.
Any other questions under like family and foster care? Okay. All right, the Center for Healthy Communities covers elder law, health insurance, and public benefits. So this issue has come up for years and years and years in the General Assembly and hasn't gotten anywhere, but we will, again, working with many other people, try to increase the staffing ratios. One thing that might be a little bit different this year is a Virginia Legislative Commission, which came out with a report last fall, is recommending minimum staffing requirements for nursing homes. I think this was the Joint Commission on Healthcare. I don't know. Is Emily on the call or not? I don't. No. Okay.
It was the Joint Commission on Healthcare, though.
Okay.
It was one of
Thanks.
the big studies this year.
All right. This is a lot of people are working on now. Guardianship reform. And this has to do with increase. There was a JLARC. I think it's a JLARC study. Hang on a minute. Yeah, the JLARC study that there was that found that most at-risk adults aren't sufficiently protected by the state's private guardianship system, according to a new report from JLARC. And that was again last fall. So and they recommended something like 30 or 40 changes, but we're focusing on 3 changes that were recommended in the report. Increasing access to the public guardian program. This is a public guardian program is when somebody needs a guardian, and this is, again, it's almost always these are adults that are disabled in some way and need somebody to help either make decisions for them or but basically usually decisions. And it can be limited, can be full guardianship, but what if you don't have anybody who's willing to be the guardian? But then you can turn to the public guardianship program, which has been around for many years in Virginia. So we want to try to increase access to the public guardianship program and change. There's a backup of people needing a public guardian, but there's not enough funds allocated to this. And we also, the other thing that's mentioned here is we want to change the role of a court-appointed guardian ad litem. So when you, in order to get a guardian appointed for an adult in Virginia, you have to file a case in circuit court. And the guardian ad litem is the person that the court appoints. It's an attorney, and that person is supposed to do some investigation and report back to the court about whether this person should or should not, does or does not need a guardian. And I think the feeling is that the guardian ad litems don't necessarily think too much about whether there could be other less restrictive options. And so the legislation would put that requirement on them. All right, well, let's, before we get to health insurance though, was there any question about the guardianship? We don't have Emily, but I could probably try to answer. Dana, anybody?
I don't see a question about guardianship. I see another question about TANF.
Okay.
So we can. Right. Well, we're
Health
getting
insurance.
to the public benefits section. So we'll get there in just a
we're
moment.
almost there. Hang in there. But another really interesting subject though, of course, is health insurance. And we do have our expert on here, Sarah, I believe. Do you want to say something about this, Sarah?
Yeah, good morning, everyone. Thanks for joining us. So this is VPLC participated in a work group that came out of budget language last year, looking at a state-funded Medicaid-like program to cover children regardless of their immigration status. Last year, we extended coverage to pregnant women regardless of their immigration status, which is a Medicaid option that we adopted, so we could get federal funds for that. This would be exclusively a state-funded option. So we're excited to be part of that work group. TCI has done a huge amount of work on this, so I definitely want to give them credit. But even if it doesn't pass this year, certainly an issue we will continue to work on going forward. And I apologize for the cat in the hat in the background for everyone. I do have a COVID positive child home with me today, so apologies if that's coming through.
All right, Sarah, do you want to say something about this slide?
Yeah, so there were just several DMAS budget requests to kind of remove administrative barriers. So a lot of this is going to be in the budget. Some of them made it in, some of them didn't. One was removing into the governor's budget. So removing the small copays that are in the fee for service program, as well as the CHIP programs. So that a little bit higher pregnant women and children in Virginia who can still get state-based coverage. Making sure we were hoping to get 12-month eligibility for children. That wasn't in the governor's budget, but we're also combining the CHIP and Medicaid programs, and then combining our MCO programs is a pretty big lift that the state's looking at that we support. And then one additional thing we're working on is streamlining the Medicaid process for SSI recipients. Virginia is one of 9 states that doesn't automatically find SSI recipients eligible for Medicaid. And Emily and I are working and hoping to change that this year. It just creates a lot of administrative burden on the individual as well as the state to get and keep those people in coverage that they obviously very, very much so need.
Okay, Dana, next slide. All right.
And these are things that we opposed in the last several years and were able to get governor's vetoes on. And we've already seen several association health plan or in this case, multiple employer welfare arrangement bills be posted, as well as a bill to roll back limitations on short-term limited duration plans that was passed in 2020. So just looking to kind of protect the gains that we've made, although it is going to be quite a fight to prevent the association health plan bills from going through this year. And last, we're working again with LAJC on some improvements to medical debt collections, and one bill specifically on language access within the hospital system to make sure folks are aware of not just the program, but the processes on how to access the program. We find that this is just a barrier for eligible individuals, and then they end up with medical debt, and it's just kind of this domino effect where if we can help them get in the program that they're eligible for early, which includes a charity care, but also Medicaid or the ACA, get them in coverage, it can really prevent those downstream negative impacts. And Delegate Tran has been working on this and is very interested in language access kind of more broadly across the state.
Okay, public benefits. I think Salam is on the call, right?
Yes, I'm here. Good morning, everybody. So one of the things we'd like to do is increase access to SNAP by allowing incarcerated individuals and soon to be returning citizens to apply for SNAP prior to their release so that they have access to SNAP as well as to the education and training programs part of the SNAP program as soon as they are released, as opposed to having to wait 7 to 30 days for DSS to process their applications upon release. So we're going to be working to get that language right with DSS so that it's something that they can do with their short-staffed agencies, but while also making sure that returning citizens have that advantage of when they come out. And this is going to be a way to help reduce recidivism as well, because when you're thinking about returning citizens, oftentimes they are low income, they don't have resources or familial help that can help them through. Those families are already struggling themselves. So this will definitely be able to help them at least put food on the table. Next slide. So we want to, there's something within the TANF policy called full family sanction. And what this means is that when one of the adults doesn't comply with the education or workforce component of TANF, then the whole household is penalized and they lose their cash assistance for until the adult is in compliance. So what this is effectively doing is it's hurting the kids in that household. So what we have done is we're going to have a bill that will adjust this. It's going to say which part of that cash allotment is for the children and which part is for the adults. And then it's only going to sanction a percentage of that portion for the adults when they are not in compliance with the programs. And that way the kids are still going to be able to get that cash benefit.
All right, I think there were some questions on
Yeah.
public
So,
benefits.
thank you, John, for those excellent questions about TANF. I'm just going to pull them up in the chat here. So yes, one of those questions was about how there's a lot of people dipping into the TANF fund, into the TANF grant to fund their own projects and to fund projects that are not related to giving money to needy families. And it's in the tens of millions that is being taken away. So what we're seeing is, if you look at the governor's proposed budget, the TANF funds, the availability of funds by the end of fiscal year 2024 is going to be a very low $16 million. And it's been decreasing by about $40 million every year, which means that fiscal year 2025, it's going to be in the negative. So it's a very dire period for these programs that are being funded by TANF that shouldn't be funded by TANF. And we do have a list of those that we've collected and compared with DSS to see how we can start, peeling that funding away so that the needy families are the ones getting the money. Now, last year with Delegate Rasul and Senator McClellan, we were able to get a budget amendment through that would increase TANF benefits by 10% every year until it was matching 50% of the federal poverty level, and then staying consistent with that until forever. And so we thought that we wouldn't have to do that this year because it was set in the budget. That's the law, but unfortunately, it did not get funded in the governor's budget. It is there in writing. It just did not get funded, so it's an unfunded mandate essentially because of that reduction in the TANF balances. So we're going to be reintroducing that budget amendment to get that 10% back up and running, and then let everybody else figure out what is going to be decreased in TANF funding so that the families can get that money. And as for the fact sheets and bill numbers and everything like that, we will have that out as soon as the bills are finalized, and we'll be able to share that.
And Salam, I think there was a question just about who the patron of the repeal of the full family assistance was.
Yeah, it's Delegate Sickles.
Thank you. And then I think there was a question about, I can go back, about why, I think Don asked, why are non-ACA compliant plans allowed at all? And I think Sarah answered in the chat, but I don't know if you want to elaborate or say it verbally for anybody who's on the phone, Sarah.
Yeah, I'd be happy to. So short-term limited duration plans have always been allowed, but under the ACA, they were limited to 3 months with the Obama administration. The Trump administration rolled that protection back and allowed them to be available for 12 months. And so those do serve a purpose. They help folks who are in transition or who maybe just need catastrophic coverage for a short period of time. And so it makes sense that we wouldn't eliminate them completely, but preventing people from using them as full coverage is helpful because often they don't cover labor and delivery or prescription. They have pre-existing condition exclusions. So we've had folks enroll in them and then come into our Navigator program after open enrollment because they can't get the prescriptions filled. And outside open enrollment, it's very difficult to get into the ACA market. And so we were proud of being able to limit that so we can help consumers get into ACA compliant plans, make sure they know that they're eligible for the tax credits and all that financial assistance. The AHPs, it's a little more convoluted. Often these plans are defined as not insurance, but then put under the BOI. So there is some question as to, are they allowable or are they not? Often they allow, the goal and the talking point is that we allow small groups to come together and access the large group market. The problem there is that it's not fully regulated at the state like the small group plans or the large group market like ERISA plans at the federal government. And so there's a lot of loopholes and a lot of protections that get lost. But there's also Trump era rollback of HP protections that are currently in court. So there's also still some gray area there.
Thanks, Sarah. And then I think we had a question from Marty. Will VPLC be working with LAJC to make permanent some of the worker protections gained in 2021, including an unemployment insurance overpayment waiver to forgive no-fault debts when repayment would threaten basic necessities? Jay, I don't know if you want to take that. Or not. We have typically supported a lot of those efforts in an assist capacity and are planning to be in that same capacity this year. So Marty, we'll be walking the halls and available to support all of those efforts.
There's a link on this last slide where you can join our email list, or you can put your name out there so you can get action alerts on different subjects. So I would encourage you to do that.
And please feel free, if you still have a question about any of the issues that we're working on, please feel free to raise your hand or ask it in the chat. I did just want to say thank you so much to everyone who's joined us this morning, all of the VPLC staff, but also all of the legislators, legislative aides, and all of our supporters who are here this morning. Very happy to see all of you. And for the legislators on the call, thank you so much for joining us. I know this is the first day and a very busy day, so we appreciate your time. And for everyone, all of our supporters, thank you so much for the great questions and for making sure that we have a lot of other folks behind us as we're launching ourselves into this legislative session. It's different every year, but it is crazy every year. So we appreciate all of your attention to these issues, chiming in, sending emails, contacting your legislators, and helping us in our advocacy efforts. And as we move things through this session, this will be a sort of like every year, there's going to be twists and turns. So please stay tuned. You can go to our legislative advocacy website page and either sign up for our email updates and action alerts, or you can just periodically join the page, and all of our updates on our bills and information will be available there as well.
All right. And as Ezra said in the chat, he'll be sending out an email later this week with the slides, the recording of this presentation, and other resources. Be on the lookout. The email from Ezra.
And I think with that, thank you so much.
Thanks, everybody.